I'm Clearwater Estate Planning and Probate Attorney Carol Lawson. A question I was recently asked was, does a land trust or an LLC offer better protection for rental properties? Any information I give is limited to Florida law. So, anytime you have an investment or rental property, it is super important that you put it in some type of entity that is going to give you asset protection. Why? Because you don't get the homestead protection. And especially as a rental or a flip, you are at a much higher risk of liability. To make sure that you are protecting any other properties that you may own as well as your personal assets, you need an LLC or a land trust. What's going to give you better protection, a land trust or an LLC? The answer is they both give you the same protection. Asset protection is asset protection. Either your assets are protected or they're not. The difference between an LLC and a land trust is that even both type of entities give you the same asset protection. With an LLC, you can risk losing that protection very easily. Whereas with a land trust, you cannot. How could you lose your asset protection with an LLC? You can commingle funds. You can fail to comply with the corporate formalities, such as having meetings and reporting annually, minutes, and things of that nature. You have to be extremely diligent in making sure that you are treating your LLC as an entity, that it is wholly separate and apart from you, the individual. Because if you don't, the law is not going to treat the LLC as something wholly separate and apart from you, the individual. It is going to pierce the corporate veil that protects your assets, and you are going to be personally liable for any liability that attaches to that property. With a land trust, it's a lot more user-friendly or easy to use in that way, and there's no corporate formalities to follow because it's not a corporation. It's not a corporate entity. There is no corporate veil to pierce because, again, it's not a corporate entity. A trust is a private agreement between the trustee and the beneficiary. That trust agreement governs the relationship between those parties, and you have a lot more flexibility in how you choose to manage the property. You can commingle. You can do things that would really make the trust look like just an extension of the beneficiary. Should you commingle? Probably not. But if you do, you're not going to lose the asset protection that a land trust gives you, whereas with an LLC, you would. A land trust also has additional benefits, like it provides privacy and confidentiality for the owners, whereas, at least in Florida, a Florida corporate entity will not have both of those. You're going to provide, and they're both not have both of those. Both of those are going to provide you an avoidance to probate, meaning it allows you to devise or give your property to your heirs upon your death without going through probate. However, with an LLC, you need to have an operating agreement that names your heirs. Most people go online, they set up their LLC in 5 minutes, and they think that they're protected, and they think that they're avoiding probate, when they're not. And then with the land trust, once you set it up, you are good to go. There are no annual reviews. There are no need for you to make sure that you do so. There are no filings with the Department of Corporation. There are no renewal fees that you have to do with the state. It is not recorded. It is not public record. So if you can't tell by now, my recommendation is for any people in Florida to set up their property in a land trust. LLCs can work. I do have clients that use LLCs, but you need to make sure that you are educated, that you have professional guidance professionally drafted operating agreements in place, and that you are operating it correctly pursuant to all the legal requirements so that you are, in fact, protected. Hope this helps.